Pretoria High Court has requested defence lawyer Advocate Charles Mnisi to present concrete evidence in his submissions in the Meyiwa murder trial. This relates to charges against his client Nthabiseng Dubazana, who is accused number 3 in the case. Mnisi submitted that there are changes to a plea Dubazana previously made regarding his charges of unlawful possession of a firearm. He was arrested in 2015 for a different case in Alexandra.
My Lord, I'm specifically referring to what the state is alleging against him in count number 4.
Those are instructions. I've been acquitted, I've been charged, and I served a sentence. What was the sentence?
No, he doesn't say he was acquitted, my Lord.
Oh, what does he say?
He was convicted.
Yes, what is a sentence? If you're convicted, you serve a sentence.
I don't think that the issue of a sentence for now is relevant.
It arises.
Yes, it's got to
ask
be
your
determined.
colleagues here.
No, it's not relevant, my Lord.
What? You are charged with murder, like Ratam Khwashing. And then you say, oh, my sentence of life is not relevant. Is that what your submission is?
So the court basically wants all the particulars in relation to this?
Yes. The court has a duty to investigate whether, in fact, what you are saying is correct. Then I'll go to the state and say, but this gentleman has served the sentence, or he's due to be sentenced, or there was a trial,
yes,
and he pleaded guilty.
I thought, my Lord, that will come at the end of the trial.
No ways.
When the guilt or the not guilt of the accused is supposed to be
No, you told me about acquittals and convictions.
Meanwhile, State Witness Sergeant Timothy Matabula has echoed evidence regarding empty alcohol cans found at the Kumala homestead when the police arrived. Matabula says it appeared there had been a party prior to the deadly shooting. He's among the first officers who responded to the incident.
Which part of the house did you gain ingress into the house?
The kitchen. The kitchen door.
Yes, you may proceed.
Yeah. I check, just when you mix up cans, we checked, and then it was sort of mixed up. On the one side, we saw cans of alcohol. It appeared as if that there was some party or something.
And where did you see these cans of alcohol?
We were pants. I think they were on the floor in the dining room. Okay, we inquired from him as to what happened. He informed us that he didn't have information. The people with information are at the hospital. They all left. But what he knew was that Senzo was shot.
Legal expert Nthabiseng Dubazana joins us for more reaction. Nthabiseng, appreciate your time this afternoon. Just give us an overview, if you will, of where this case stands at the moment, certainly based on what's happened in the last few days.
Where we stand, I believe, is the contamination of the crime scene. So therefore, the reliability of the evidence that is used by the state against the accused persons, whether it was not contaminated. And the main reason for this is that in terms of our criminal procedure, it's what we call chain evidence. So in other words, the first respondent or person to be at the scene in terms of the SAPS, that is, they have to bag and tag, for lack of a better term, the evidence that they find there, and then they have to give it a unique number, which they're going to send either for forensic to go and look at, etc., etc. So in this situation, it seems none of these things happened. So in other words, now, if the scene is contaminated, how then do you connect everything that happened at the scene with the accused persons before the court? So I think that is where the state now has to try and clear up the murkiness that has come up and try and bring up the case yet again, because at some stage it was a little positive for them. It looked like the state has a strong case, but with the evidence, the chain evidence seeming to have been broken, you cannot, as a result of chain evidence having been broken, conclusively say that the accused persons are the ones who indeed committed the crime on the day in question.
Now, one of the respondents, when asked, said he'd been in the force, I think, 5 or 6 years. So if you've been in the force 5 or 6 years and you're faced with a crime scene, as was faced in the Senzo Meyiwa murder trial, is it ineptitude that results in due diligence not being done, or were these deliberate omissions, do you think?
I'm not sure what I could say to that, because it should be with the number of years that you have had experience in this and the training you would have gone to be an investigating officer. You ought to know what you're supposed to do when you get to the police scene. Or is it because it was famous people who were involved and therefore you got caught up in the situation? I am not sure. But what usually happens in the normal day-to-day crime situation, it ought to be that the what we call the arresting officers who first come to the scene, if there's indeed an arrest that's going to be done, have to wait for the IO to come through in order to do their investigation. They have to also wait for the photographer to take pictures of the scene of the crime. So, and while they're doing that, they're making sure that the scene is formally secured so that nothing is moved, nothing is tampered with, and they have to ensure they're wearing gloves, all these other things. But in this instance, it seems that that was not adhered to for reasons that are not clear to the court or to the defense attorneys when they try and get clarity from the witnesses in the box.
Now, based on the information provided, what are the potential legal implications of law enforcement not properly securing the scene?
You know what? This has been happening for so many years. I mean, in profession, I've been doing this for over, 11 years. And these are the things that happen in terms of chain evidence and securing the scene of the crime. I don't know if it is a situation wherein there is lack of training or knowledge in terms of the SAPS knowing what to do when they reach a scene of the crime. So at the end of the matter, let's say the accused persons are indeed acquitted of the crime, they have recourse to sue the state based on everything that has happened to date, the time that they've been incarcerated, unlawful arrest, unlawful detention, all of these things. And this is why the state ends up paying so many billions towards the people who have suffered such injustices as a result of the poor work of the SAPS.
Would you suggest that this is the reason that so many crimes go unsolved in South Africa?
100%. It is part of the main reasons why so many matters, even though they do get to court because there was an arrest that happens, criminal procedure is very specific. I think that's why it is important to always remember it is a beyond a reasonable doubt. There can't be any gray areas. And even if you do get convicted in terms of circumstantial evidence, it must be so strong and the investigation connected to it so strong to have you convicted. So there's things that you need to follow from the moment of arrest. You have to, read the accused their rights in terms of Section 35 of the Constitution. They failed to do this. And this is done only when they reach the police station and then they're given what we call their rights form. And they've already given detail of whatever they did or did not do pertaining to the crime that they're going to be arrested for. And that evidence is what is then put in what we call a warning statement and then used against the accused person. Already that's unconstitutional and it can't be used against the accused. So it starts from the moment of arrest all the way to the end of investigation.
Now, clearly there are multiple learning points from what's transpired and what we can pick up from this case. What would some of those key aspects to learnings be?
Firstly, it seems that that is coming out to the fray is that the investigation was not done correctly. Chain evidence was broken. When we look at the previous case, I know we're not dealing with the previous case now, but I think it is important to bring it to light. The two dockets were not brought together. They were only brought together in this particular matter. And then the only justice, quote unquote, in terms of this matter is that when they did a pre-trial conference, it included both dockets, unlike where the second docket was now revealed in the middle of a cross-examination of a state witness. You know what I mean? So the terms and conditions of how criminal procedure is supposed to be followed were not done. And then we look at witnesses. I think it is Mr. Madlala who gave evidence that he was tortured and beaten up in order to give whatever statement that he gave. Then that goes down to things like confessions, how confessions are made within our country. They have to be reduced to writing in front of a peace officer and a magistrate. whatever the case may be. Section 218, Section 219 of the criminal procedure comes into play. So there were a lot of things actually that went wrong in this case. I don't know if justice will be served. In other words, we will know what happened on the day in question or not. But so far, I don't see how the state is going to resuscitate this case.
Legal expert Nthabiseng Dubazana, appreciate your time this afternoon.